Good morning and welcome, everyone. Hopefully everybody can hear me okay. Good. Great. Well, thank you for joining us. I'm Janice Jones. I'm the Executive Director here at the Public Justice Center. PJC uses legal impact tools to fight for economic justice and race equity in Maryland and beyond. So I want to say good morning. Thank you for joining us bright and early. 9 o'clock in the morning, we really appreciate. So great to see so many of you here. And thank you to our staff, our board members, our clients, our donors, our funders, community partners, and other stakeholders for joining us this morning to talk about our interesting year in housing that our housing team is going to talk about shortly. But your presence shows our shared commitment to housing justice in Maryland. So our Human Right to Housing project is critical to the affordable housing ecosystem here in Maryland, and has been there a very long time and will be there in the future. Support for our project is essential for free and robust housing legal representation that makes an impact. Secure housing in our community in Maryland is key to economic justice, enabling education, employment, and financial stability. So our Human Right to Housing project, hosted today with Matt Hill and Abra Turner, is key to making sure that Marylanders thrive. And so thank you for your support and commitment to housing justice. And so now I'd like to turn it over to our dynamic duo this morning from our Human Right to Housing team to begin the discussion. Thank you.
Thanks, Janice. Again, my name is Matt Hill. I'm an attorney here at Public Justice Center. And I see we have an initial question from Sarah Weber. And Ms. Weber, if you'd like to ask the question, then I think we're going to hold all other questions for the end if we could.
If there was a question, that was a mistake. I was just typing in where I was from. So
got it. Okay. So again, my name is Matt Hill. I'm an attorney here at Public Justice Center. And Albert Turner, my colleague, will be coming right after me. And we're going to talk about housing justice advocacy at the Public Justice Center in Maryland's Year of Housing. We've got quite a few slides here. I'm going to go fairly quickly because I think that we all want to have a chance to have some robust discussion. So just a little bit on the agenda. We're going to talk a little bit about some of the supply issues, but just very briefly, we know that housing supply, and particularly the development of new affordable housing, is a huge part of resolving the housing crisis. We're going to talk a little bit about some new laws that are coming into effect. Recent Maryland Supreme Court decision, Westminster v. Smith, right to counsel and eviction updates, and then a couple bills that are coming back in 2025, and then some enforcement issues around source of income discrimination, and finally some Baltimore City-based advocacy that we're engaged in as well. So talking about supply, that's where most of the public attention, I think, has been in Maryland's Year of Housing, and trying to estimate what the need is. You can come up with 5 different numbers from 5 different groups. And it depends on what level of income you're talking about, but generally tens, hundreds of thousands of new units, particularly of affordable housing for very low and extremely low income households, are needed throughout Maryland. And Public Justice Center is involved in some of that advocacy. For instance, we supported the governor's housing expansion bill. This is going to help to modulate some of the zoning challenges that affordable housing and market rate housing projects face throughout the state. We represent the Baltimore County branch of the NAACP in monitoring enforcement of a conciliation agreement in Baltimore County. This conciliation agreement, among many other things, is intended to produce 1,000 new units of affordable housing in opportunity areas throughout the county by 2026. I'm not ready to go into a detailed report on exactly where that agreement stands at the moment, but safe to say that the county has made progress And there are a number of outstanding enforcement issues. And then, unfortunately, the Baltimore County Council seems to every year or two come up with some new idea to try to undermine the conciliation agreement. The latest is a Council Bill 3124, which would greatly restrict the development of a lot of housing throughout the county, because it would say that unless the county already has adequate school capacity in the jurisdiction where the housing is being proposed, that development would be put on hold for 5 years. That's at least what the current language of the bill says. And so that, known as an adequate public facilities ordinance, if it passed in that form, would be a death knell, frankly, for the development of any affordable housing in opportunity areas in the county. So we've been partnering with a number of opponents of the bill. We've been representing the NAACP in testimony, in meetings with council people. If you are in Baltimore County and you'd like to tell the county council that you are opposed to this bill, happy to send you some talking points. Just send me an email and I'll send you, I'll put my email address in the chat later. We were a part of the coalition that supported Baltimore City's inclusionary housing bill, which is projected to create 1,000 new units over the next 10 years, essentially leveraging future development of market rate housing and making some of those units affordable. And of course, we're still involved in supporting implementation of the Baltimore City Affordable Housing Trust Fund. This fund is taking in roughly $15 to $18 million a year and has a priority on community-led development, housing preservation, emergency rental assistance, and a number of other critical housing priorities for Baltimore City. And I'm part of the commission that oversees that, and we still coordinate some with other parties who are interested in advocacy around the trust fund. All right, so that's supply, not our primary focus today, but certainly something that we care about deeply and have advocated on and will continue to advocate on going forward. Next, a couple of bills that recently passed in the General Assembly that I think are important. First is the Tenant Safety Act. This is about holding landlords accountable. When we talk about the housing crisis in Maryland, supply is critical. Holding landlords accountable for conditions of significant disrepair is equally important. And that's because Maryland has an enormous number of very inadequate or extremely inadequate rental dwellings in the state. 66,000 severely or moderately inadequate rental dwellings. The main way in which tenants can hold their landlord accountable is through a rent escrow, where you pay your money into escrow until the repairs are made. Only 1,959 renters took advantage of a rent escrow in 2023. There was a Baltimore Sun study from a few years ago that found that only 6% of the cases it reviewed in rent escrow actually resulted in reduced rent. And so the system was not working. Landlords were cheating the system. They essentially developed a business model of taking as much rent in as they could, investing as little in the property as they could, and then essentially waiting out the clock in court to continue with that practice with the next tenant. So how do we fix this? One aspect of this is the Tenant Safety Act. And let me step back for a second, because with the legislative work I'm going to talk about in Annapolis, all of it is a team endeavor. So we're part of the Renters United Maryland Coalition. I know there are a number of folks on the call here who are part of the Renters United Maryland Coalition, who fund members of the Renters United Maryland Coalition. And we all bring various strengths to RUM, and we bring those strengths down to Annapolis. We decide on an agenda, and then we use communications, organizing, policy, research, lobbying, the full panoply of advocacy tools to advance that agenda. And so coming out of that coalition space was the Tenant Safety Act, is the Tenant Safety Act. And that's really going to, we think, help tenants take advantage of the rent escrow process and hold landlords accountable. Does 4 things. First, it's going to clarify that tenants in the same complex with similar issues may join together in an escrow. This is to increase pressure on the landlord. Instead of not getting the rent from one tenant, they're not getting rent from 20 tenants. And then help corroborate evidence, right? If one tenant's talking about what they are experiencing in Unit 1 and tenants talking about the same thing in Unit 2, it's going to help the judge understand, wait a second, I should really believe these tenants. This is serious. You see in the background there, one of the rallies that we participated in support of the Tenant Safety Act, again, with strong support from CASA, from Progressive Maryland, the Youth Action Board, a number of other organizations were involved in this. And so I really, really love the work with RUM because it does bring together a lot of grassroots and policy advocacy. What else? Making it more accessible. So we're going to create certain presumptions through the Tenant Safety Act. The presumptions are the tenant should pay rent into escrow going forward, not the past due rent and fees. The burden is going to shift to the landlord from the beginning to show why the rent should not be reduced. And the tenant can request the court to hear rent abatement up front, not at the end of the case. These are all sorts of attempted to overcome certain barriers that were keeping a lot of our clients and a lot of renters in these groups out of court. And so we're going to shift the burden to the landlord to show cause why the rent should not be reduced and why the rent escrow should not go forward. There on the left, you'll see a couple of Progressive Maryland tenants in the Enclave Tenant Association showing the chair of judicial proceedings, Will Smith, around some of the serious conditions of disrepair in their building. Third, it's going to create a explicit warranty of habitability throughout the state. It's very broad. It's going to be a lot broader than what we have in Baltimore City. And this is going to be a really powerful tool, I think, to help tenants get a refund of the rent that's already been paid and any expenses they've incurred when the landlord has failed to make repairs. It's also going to allow the court to terminate the lease and pay security deposit and relocation assistance. This is really important, too, because the warranty of habitability does not require the tenant to pay rent into escrow. A lot of tenants want to get a refund of the rent. They want to terminate the lease. They want to get out. And so this is going to be an important tool to allow those tenants to do that and to meet their goals. Finally, attorney's fees to prevailing tenants. Most landlords have attorneys in these rent escrows. This is going to help tenants obtain attorneys as well. This also increases the pressure on the landlord to make repairs because the landlord will know, hey, if I make these repairs, this case will end and I'm not going to owe a bunch of attorney's fees. So we hope that all these increase leverage for tenants to hold landlords accountable in escrow and similar actions. Second, really important, around eviction prevention funds. This is the second big bill that RUM supported and that we're really excited about. What are eviction prevention funds? First, they pay 1 to 3 months of past due rent for families who are facing a short-term crisis, ensuring a missed month's rent doesn't cause homelessness. The coalition is not just RUM. We kind of expanded the coalition to include a lot of social service providers, local government partners, and created the coalition MEPFA, the Maryland Eviction Prevention Funds Alliance, really born out of the fact that during the pandemic, eviction prevention funds used to be called emergency rental assistance. And emergency rental assistance was very effective at keeping people in their homes during the pandemic. And so how do we continue that policy and that support for housing stability going forward? And that's what MEPFA took on. Got some foundation support from ABLE, Casey, United Way, funded Stout, Rissius, and Ross to talk about, okay, what's the need for eviction prevention funds in the state? How is this going to help people? How many households are going to be able to avoid eviction and homelessness? And concluded, after engaging lots of stakeholders, lots of data, that $40 million a year in eviction prevention funds would stop the eviction of 15,000 families who are at the highest risk of homelessness in the state. Turn that into an advocacy campaign with support from Advance Maryland, a number of other folks, and really talked about both the impact of homelessness on families and how the state actually can save money on social safety net costs by investing in eviction prevention. And concluded from Stout that every dollar invested in eviction prevention saves the state $2.39. So a pretty good return on investment. And the reason is, and this is what I think is really exciting about the report, it highlights the intersectionality of eviction prevention, of preventing homelessness, with everything that we know who are on the ground working with folks. That is that, when folks are homeless, they use the emergency room as their primary care doctor. State often pays for that through Medicaid. When children become homeless, their learning drops. They're not going to be doing as well in school, and they lose access to critical supports, particularly in community schools that I'm going to talk about in just a minute. There's good data around how becoming homeless forces people to lose their jobs. And if they're not, maintaining employment, they're going to be much more reliant on the social safety net. Foster care has a similar impact. We could go on and on and on. And that's what I think the report does a really good job of. And so I just wanted to take you through a few of you all have already heard this, so I'll go very quickly. But on the issue of homelessness, Stout found that 15 to 25% of families who are evicted become homeless. And so really making that connection between stopping evictions and stopping homelessness. Again, you'll see there some data that we relied on talking about how evictions went down by 50% during the pandemic, in large part because of the investment in emergency rental systems, the investment in right to counsel and evictions, the different legal reforms that took place during the pandemic. And we really centered a lot of our clients and a lot of the organization members of the different groups that were behind MEPFA. And so there's one of our clients who agreed to be featured in the report. One of the things I was really excited about is we actually got to provide a small stipend to the clients and the members who agreed to be featured, to come to the press conference, to share their story. And so that's April Taylor, who I got to know pretty well, who was facing being evicted again after just coming out of a homeless shelter 2 years ago. In her situation, she was working at a McDonald's, and the McDonald's had to renovate their lobby. And she lost hours at the restaurant because of that renovation process. And that loss of income compounded, because then there are certain fees that get added to things like your rent and late fees on other things. And suddenly she was facing a deficit of a couple months' rent, even though she was working again and working full time at that point, that she was not going to be able to get out of that hole without help from an eviction prevention provider. Children, really highlighting the impact of eviction and homelessness on families with children. Super important, especially as we're looking at the state investing $3.8 billion a year for the blueprint, right? If the kids are evicted from the community schools that are getting a lot of the money from the blueprint, they're going to lose access to those community supports and likely move into even worse situations. And so making that connection between education stability and housing stability. Another client who we got to know really well, this was actually a CASA member, Magdalena Escobar, just talking about her experience actually having to quit her job in order to take care of some urgent health needs for her children, and the family's attempt to bounce back after that, where she needed eviction prevention funds to get over the hump. Two of my clients who I really admire, Sylvia Duvall and Abdul Muhammad. Mr. Muhammad, his car was stolen in the rash of car thefts in Baltimore City that I'm sure most of you heard about. He lost his job because of that. He couldn't get to work. And so that put them a couple months behind on the rent. And they needed emergency rental assistance or eviction prevention funds. And they actually eventually got those funds through United Way. But they were willing to tell their story. And that helped us also highlight the importance of eviction prevention funds on racial justice and race equity. Looking at the fact that the vast majority of the households who were helped by emergency rental assistance during the pandemic were Black and female-led. And so when we look at structural housing racism, I mean, one of the stats that blew me away is just that 1 in 4 Black children in rental housing are right now facing the threat of eviction in a typical year. And yes, we have to invest in helping folks access homeownership and other ways of creating more structural equity in housing. But we can't ignore that people who are facing eviction right now are overwhelmingly, disproportionately Black and women-led households. And so creating more robust safety net is part of race equity. So we had a good press conference. We participated in a number of marches, not marches, rallies. We really lifted up our client stories and meetings with legislators, hearings, And through a lot of good advocacy, a bill passed, which is really exciting. This is going to, in FY25, have $5 million focusing eviction prevention funds on families with children in community schools, which I touched on earlier, really leveraging the Blueprints investment in families who need it the most. Maryland Department of Housing and Community Development is going to administer with outreach support from schools. Really thank the department who we built a strong relationship with and who supported this bill and said, you know, one of the things when you're doing this kind of advocacy, if the agency that's going to administer it comes in and says, nah, this is too hard, this is too complicated, what about this and what about this, then the bill's not going to pass. But DHCD, to their credit, and the Department of Education said, no, look, this is really important and we can do this. And so they worked with us and the sponsors to iron out a few of the wrinkles and get the bill passed. This is a really broad bill. It has broad eligibility. It has broad uses. And then again, of course, it's funded, again, $5 million FY25. There's also going to be 10% of a certain increase in court fees I'm going to talk about in a minute that's going to go into this going forward. But it is going to need a budget allocation each year. So that's going to require additional advocacy and hopefully an increased budget allocation. More exciting, too, is we have $5 million in the budget for general eviction prevention funds in FY25 outside of the community schools framework. And I think when I was creating this, I wanted to just note here that this isn't just a 1 year of advocacy and 1 year of a study. This is built on years of advocacy and years of, frankly, of failure. Right in General Assembly 23, we launched a really robust campaign on eviction prevention funds and completely failed. And yet, I think we laid the seeds in that campaign to come back and have this success this year. And so we're really excited about that. Where do we turn next? On implementation, we're partnering with DHCD. We've had one meeting already. We've talked about, you know, what the data needs to be collected to show that this is effective, what policies need to be in place to be able to show that this kind of program is effective, all laying the groundwork for then advocating for more funding, assuming that we can show effectiveness. Because we know that $10 million is not much, and it raises questions of equity and how that money is going to be used. And then two, Stout's report also developed a number of best practices based on the review of literature from around the country, based on talking with stakeholders in eviction prevention funds, landlords, government agencies, tenants throughout the state. And so wanting to incorporate those practices will be really important as well. Next bill, HB 693, the Governor's Renters' Rights and Stabilization Act. I'm most excited about the provision that's going to decrease the maximum security deposit from 2 months to 1 month. I think that's going to help a lot of tenants who need to move for all sorts of reasons, whether it's to get to closer to a job, or they're getting out of a domestic violence situation, or you know, they're just living in an uninhabitable unit and they need to move into something that is actually safe. The security deposit's a big barrier, and so this is an important aspect of the bill. It's going to increase the filing surcharge for all civil cases. Third, it's going to increase the summary ejectment filing surcharge. So to be clear, that's for eviction for failure to pay rent. Initially, it was not going to be, the landlords were not going to get to pass that on to the tenant. However, the Senate amended the bill over our objections, over a lot of advocacy on our side, and it's going to allow landlords to collect that increase. It's $35 from the tenant if the landlord obtains a judgment in the case, and only out of the security deposit. So it's not going to be added to the amount the tenant has to pay in order to pay and stay, but it will be allowed to be withdrawn from the tenant's security deposit at the end of the lease, which is really unfortunate. But the money's good, and it's allocated for an important purpose around housing stability, which is a statewide housing voucher program modeled on the Housing Choice Voucher Program. It's going to provide funding for Maryland Legal Services Corporation, in part to implement the Right to Counsel initiative. And then 10%, as I mentioned before, is going to go into this eviction prevention funds in community schools. It's also going to, the bill also creates a tenant opportunity to purchase and right of first refusal. And I think, you know, we're interested in this, and we're interested to see how it plays out and how many renters are actually able to utilize the process. Third thing on the agenda, I promised to move more quickly. Biggs, Supreme Court of Maryland case opinion, Public Justice Center's co-counsel along with Brown Goldstein Levy and Santoni Bacci Ortega. We filed this case back in 2017. Just look, we found this landlord, Westminster, and they were consistently charging tenants both a 5% late fee as well as additional fees when the rent was late. They had lease provisions that said they can collect anything as rent in rent court, where tenants have very little due process. And they also said, look, we can take their payments as well and allocate those payments first to all sorts of other charges before we allocate them to rent. And so we pursued this case since 2017, and finally in 2024 have an opinion from the Supreme Court of Maryland. We lost in the trial court. And now in 2024, we have an opinion that's really clear, right? And rent means rent. Rent is what everyone thinks of as that fixed periodic sum due for use and occupancy of the property, $1,000 a month. It's not every other fee that the landlord wants to charge the tenant. And that's really important, again, because of how quick these failure to pay rent evictions are and how little due process tenants have. It's important to stick to what is actual rent and not whatever the landlord says is rent. And to be clear, that 5% late fee cap, right? That's the most the landlord's supposed to be able to charge, 5% of the rent that is still outstanding for the month. That includes their collection costs. They don't get 5% plus whatever they spend to collect in that month. So that's really a big win for Maryland renters and for our clients who've stuck through with this case. We filed as a class action. Class certification was denied in the case in the circuit court, and the Supreme Court said, okay, now this case has to go back to the circuit court and give the plaintiffs another chance to argue for class certification. And so we're right now in the circuit court waiting to get hopefully another argument on our outstanding motion for class certification. What's the anticipated impact? Well, we think that landlords, if they want to stay on the right side of the law, are going to revise their leases. We think that we'll see fewer questionable charges related to late payment. So hopefully tenants aren't going to, that slew of fees that really puts tenants deeper in the hole when they're a little bit late will become slightly less burdensome because there won't be as many. And we also think that this is going to decrease summary ejectment, this is the failure to pay rent complaint filings, because now landlords aren't going to be able to pass on so much of those monthly collection costs. And because of the governor's renters bill, the amount that landlords are going to have to pay up front to file a failure to pay rent complaint is going to go up. It's going to make filing for eviction more expensive. And so we hope that landlords will think twice about filing that rent complaint, maybe engage in sending a letter, knocking on the door, trying to arrange a payment plan. And so we hope this will decrease the number of filings and reduce that negative impact of serial eviction filings on a tenant's credit and rental history, which is incredibly important to our clients. Right to counsel and eviction updates. First, targeting full implementation in the bill currently for October 1, 2025. Right now, the funding is at $14 million a year because of legislation that we worked on before with a large coalition. That's through FY27, plus some supplemental funds from Baltimore City. We know this isn't going to be enough. Again, HB 693 increases the funding of the Maryland Legal Services Corporation, which we think will be used in part to fund right to counsel and evictions implementation, but it's unclear exactly how that's going to work. There's a good report from the Maryland Access to Counsel and Evictions Task Force, which PJC is an active member of. And so the FY23 numbers are the last ones we have available. And so again, that's through June 30th of 2023, when we were really still kind of getting things up and running. And we had 3,795 cases where tenants were provided full representation, and 76% of those households avoided disruptive displacement. So that's kind of the top line number. Obviously, we're coming to the end of FY24. I anticipate that we're going to see a significant number of additional cases where tenants have been assisted, and some similar sort of numbers on the outcomes. We're also hoping to see some initial evaluation from Stout. So Stout, Ristius, and Ross has done a lot of work in Maryland around evaluating evictions, evaluating programs, is now helping Maryland legal services organizations collect better data and analyzing that data so that we have more refined outcomes. And so we're hoping to get access to some initial reporting from that data within the next few months as well. What are some of the challenges that we're facing with implementation? I think that we still see a lot of inconsistency from the bench in their attitude toward right to counsel. Our renter is going to be able to get an initial postponement if they don't have an attorney at the initial hearing. Many times, yes. Sometimes, no. Outreach, still see a lot of tenants who say, look, I had no idea that I could get an attorney in this case. And so how do we tinker and really revamp the outreach in order to make sure more tenants are aware of that ability, and timing, making sure that tenants have that awareness and the ability to reach out to counsel in order for a legal service provider to do an intake and really evaluate the case prior to trial. These are also very challenging issues. Frankly, finding enough attorneys, hiring attorneys to be able to take these cases has been challenging for legal services providers. That's another significant barrier to implementation, and something that the task force is really working through and that we're participating in through the task force. Finally, I will turn it over to Albert, who can talk about a couple of other bills that we've been working on in the General Assembly and some of our other enforcement work. So Albert, please take it away.
Sure. Thanks, Matt. Again, my name is Albert Turner of the Public Justice Center, Human Right to Housing Division. Thank you for having me. While Matt gave kind of an overview of all the successes that we've had, I'm going to put a little cold water on that, talk about some of the things that we are still trying to get done in the state of Maryland. Rome wasn't built in a day, and safe, habitable, affordable housing for Marylanders won't either, although I wish it did. So one of the things that we worked on in session was the Tenant Possessions Recovery Act. This was a bill that was first introduced by Delegate Terrassa in 2023. 2024 became a RUM priority, which meant that we worked with a lot of coalitions to back this bill. So essentially in Maryland, which is something that I think when I have discussions with a lot of folks that they don't realize, is that when a tenant is evicted, they do not have the right to recover their personal belongings after that eviction is executed, meaning that in other jurisdictions, that's not Baltimore City, when an eviction happens, the landlord comes in and they just take the tenant's personal belongings, they just throw it out into the street. In addition to that, the tenant, generally speaking, does not get notice of that eviction date. They typically are scrounging around trying to get the amount of money to pay, or trying to figure out the resources that they can allocate to move in a timely fashion. And right now, if a tenant is evicted in Maryland, they lose that property, and it adds on to the horrors of eviction when we're dealing with losing your home and also losing your personal belongings. This is something that Maryland is way out of step when it comes to the nation as a whole. So a couple of years ago, we had some PJC law clerks do some research on this, and we found that out of the 51 jurisdictions, DC included, 46 did. 46 states had a notice or a recovery law on their books, which means that Maryland is one of 4 states that allows for tenants to lose their property after their eviction, and there's no recourse for them to get that property. So what the Tenant Possessions Recovery Act did was it would allow for tenants to, one, get notice of when their eviction date is. So say judgment is entered for failure to pay rent, a tenant holding over a breach of lease, that they should get notice of when that eviction would be coming, letting them know that either they need to move or they need to pay in order to stay on the property. So it would give them notice of that, and then it would also allow them 10 days after that eviction is executed to recover their personal belongings. So if there's an eviction that happens, the landlord would be required to keep that personal property in some safe space where their personal belongings are kept in proper condition for those 10 days. The tenant is able to come get that property, and then they can make themselves a little bit more whole after their eviction. We had a hearing in the House and in the Senate on this. You can see the picture down the bottom. Sharnae Hunt. Sharnae Hunt was someone who was evicted illegally. She was evicted in error, I should say, by her landlord. And she came home to find all her belongings were out in the streets. She had lost a lot of electronics. People had come and picked through her things. Some of the movers that had done that, they had stolen a lot of personal belongings. She lost a lot of records. She lost a lot of heirlooms, a lot of things that her son had given her. We found her story through the Baltimore Banner, which I just shared a link to, just kind of outlining the horrors of this. And she's been a really, really great resource to talk to Annapolis, tell folk that this is something that cannot be tolerated in the state of Maryland, because even in events where an eviction was done legally, that does not give the landlord the right to be able to just pick through person's property and just take it without any type of recourse from the tenant to recover. In addition, we also had a hearing in the Senate where we had the Youth Action Board of Baltimore City. They came and they testified about some of the horrors that they experienced when they were evicted and not being able to recover their clothing, their personal medications, their personal heirlooms. And we think that had a profound effect on that hearing. And while neither one of those bills in the House or Senate moved, we do want to continue on with this legislation in 2025, and hopefully we want to see this come to fruition in the state of Maryland. The next bill that we had been dealing with was the Good Cause Bill. The Good Cause Bill was something that Delegate Wilkins had been backing in the House for the last 6 years. And we actually this year were able to get through and get a bill passed in the House. This was the first time in a very long time that had happened, and we had moved on to the Senate in that regard. So the Good Cause Eviction Bill is a local enabling bill, which means that it allows jurisdictions to choose to have this on their books. So good cause meaning that the landlord, if they wish to terminate a tenant's lease, they needed to give the reason for that, and it needed to be good. They can't just terminate the lease based on their whims, based on some type of retaliation. A lot of times we see where a tenant is organizing, or the tenant has some issues with the property, legitimate issues with the property that they are trying to get rectified, and instead of handling those issues, the landlord just tries to retaliate against them and try to kick them out. And so what this bill did was, or what this bill would do is, it would allow for, it would require a landlord to give a good cause reason for the lease termination. And it's local enabling, as I stated. So this passed the House. There was a loophole that we were looking to fix, which would allow for small landlords who owned 6 or fewer units to not have to give good cause. There was a corporate loophole that we wanted to address, because in the state of Maryland, it's really hard to know exactly who owns what LLC. And so a lot of times you'll find big corporate landlords have registered 10, 15, 20 smaller LLCs or single asset LLCs where they have one unit under this one LLC, which would have given them the exemption of good cause. And so we were looking to close that loophole. And I think that Annapolis was open to getting that loophole closed. And so we're looking to have that come up in 2025 as well. Pass the House, we look forward to pass the Senate. There were a number of work groups with folk from Virginia and Maryland, the landlord lobby, the Senate, to get a good cause more palatable for the Senate. And we look to make some really good progress on this in 2025 as well. So that would in session. The next thing that we've been working with is the source of income, or the HOME Act implementation in the state. So in 2020, as many of you know, the HOME Act was passed, which was a really big step to protecting tenants, particularly tenants who have subsidies. So the HOME Act provided that a landlord could not discriminate against a tenant because of the source of their income. Source of their income usually things Section 8, HUD bash, but also it could include rental assistance as well. And typically, a lot of times you'll see landlords, they would post when they're posting their units, no Section 8 vouchers, right? And 2020, the HOME Act made that illegal in the state of Maryland. Unfortunately, that hasn't been litigated in the courts a lot. That is something that Public Justice Center has been very focused on trying to litigate, to try to create good precedent, try to create, make it known out there that this law is on the books and that landlords cannot do this. Something that we've been seeing in the last year and a half when we've been trying to find litigation on this is that the landlords have found this calculation that we think is a violation of the HOME Act, where they are requiring the tenant or the applicant to have 2.7, 3 times, 3.5 times the rent, and they calculate that using the tenant's income, and they don't include the tenant's voucher. So, for an example, say that a rental unit is $1,000, and the tenant or the applicant has a voucher that would cover the full $1,000, so they don't have a share for that. Some of these landlords are saying that, well, regardless of your voucher, you still need to show that your income is $2,700 a month, even though there are vouchers out there that would pay for the full $1,000. And we believe that is a violation of the HOME Act. And so we are looking for we are looking for tenants who fit that, and we're looking to litigate that in court as well. Some of the issues that we found in this is that because of the increase in rent in the last couple of years, that a lot of vouchers are not even covering rent. So say in the White Marsh area, a 2-bedroom, 1-bath apartment right now is going for $2,400. That is the maximum payment standard for voucher is $2,200. So even with a full voucher, they're still not being able to find that. So that's to find a unit in that area. And so that's something that we're looking to address, and something that we are actively looking to litigate. There is a case that actually is going to be on appeal in the next couple of months that we are looking to file an amicus on, and looking to support a case on, where there was a bad opinion in Baltimore County Circuit, and it's going to be appealed to the above courts. And so we're looking to help in that, and also have our own source of income case, because there are many facets and facts that could factor into the HOME Act, and we want to make sure that we're ahead of the game on that. And the next one, I'll pass it back to Matt so he can discuss some of the other source of income litigation we're doing, particularly in Montgomery County.
Yeah, thanks, Albert. And Samantha Gowing is another attorney on our housing team, and she was going to talk a little bit about some of the work that she's been leading here. She had to run to another meeting for Public Justice Center as part of a different coalition. And so just very briefly, I know we're almost out of time, but we are representing a renter in a suit in Montgomery County that involves source of income discrimination. Really good opportunity to test the source of income discrimination law, and also stand up for a renter who's working with a local renters organization to show that source of income discrimination is not tolerated, and also to test the limits of Maryland's anti-retaliation law, because we also believe that the tenancy termination was retaliatory. Finally, moving on to Baltimore City advocacy, Samantha's also been taking the lead on a good bit of that. And so we're currently working with Baltimore Renters United, Jews United for Justice, a number of other organizations in, once again, advocating in the city's budget process, focusing on funding for right to counsel and evictions, on allocating money for city housing inspectors. I mean, one of the things that we've noticed in our advocacy is just how overwhelmed city housing inspectors are. And in talking with inspectors and talking with the agency, they're saying, look, we can't even recruit the number of housing inspectors we need. We don't pay enough as a city. Anne Arundel County pays $20,000 more than Baltimore City. And so recruiting and retaining quality housing inspectors to meet the incredible demand is a real challenge for the city. Last year, they actually cut the budget for city housing inspectors. So we've been talking about this issue with council people, with the agency, and so we're lifting up that as one of the demands. Finally, $15 million for emergency rental assistance. We know that, again, $10 million on a statewide level is not enough. The city has shown that they can administer emergency rental assistance successfully, or eviction prevention funds, and had between $5 and $8 million last fiscal year for this purpose. And so we're hoping to get at least $15 million in the current budget. And it's a real challenge. I mean, the budget process is very opaque. If you ask me how much money is allocated for each of these items right now, I actually can't tell you because of how opaque the budget process is. And so working with our council allies in order to ask the right questions to figure out exactly what money is being allocated where has been the first step in our advocacy, and we'll continue with that advocacy with our partners. Additionally, the city has a law that Public Justice Center was part of advocating for that requires all landlords to be licensed. To be licensed meaning to pass a periodic health and safety inspection in order to obtain that license. A lot of problems with implementation, just a lot of backdating and improperly issued licenses, major conflicts of interest because the landlord under the current system hires the inspector. And so the inspector has somewhat of an incentive to provide for an easy inspection, so they get hired to do more inspections. And so we're at this point, not again, because running out of time will be a little short, we're collecting data on these issues. We've been testifying at a recent hearing on the Strengthening Renter Safety Act, which will address some of these issues, but also lifting up that we need even more kind of fundamental reforms, like addressing that conflict of interest. And I think that, I'm hopeful that with a new council coming in, we'll be able to get some greater traction on a couple of these issues. And finally, we're partnering with Baltimore Renters United, which has been conducting a number of listening sessions and town halls around the city and building support for rent stabilization. We think of this as an issue that's affected folks in Montgomery County and Prince George's County that have each passed rent stabilization laws. But Baltimore residents are affected as well. I mean, as Albert was just saying, certain areas, certain types of units, seeing massive rent increases. Frankly, even getting good data on that has been a challenge, but we'll continue working with our partners to explore that issue and support that campaign. Okay, I know that was a lot. I'm sorry. But we'll pause now and hopefully we can have a good discussion.
And everybody, my name is Dan with the Public Justice Center, and I will be reading the questions from the chat to Matt and Albert. So please feel free to put your questions there. We have one from Eliza. I'm curious to know more about the opposition or lack of progress to the Tenant Possession Recovery Act and to know what is preventing it from going through.
Sure. Thanks for that question. So a lot of the opposition that we've heard, obviously, is from landlords, particularly when it comes to costs. They believe that, these 10 days of having to hold on to a tenant's property is going to cut in on their profit margins because they have to flip the house, they have to hold the property, and I think that's generally kind of always the response that we get whenever there's a tenant bill in Annapolis is just the weight of cost on a landlord. Another opposition that we've seen, which I think kind of speaks to like kind of the ugliness and bad the bad understanding of tenants is that by allowing a tenant to come back to the property, the tenant would get violent and they would destroy the property or they would attack, the landlord, and that because of that, they would require the sheriff to be there. And I think we've wholly rejected that argument, mainly because we believe that by allowing a tenant to get their property after they're evicted, that would decrease the hard hitting, the horribleness of the eviction, right? You come in, you evict someone, you kick them out of their home, and you also tell them, oh yeah, you can't get your property back. That raises greatly the horror and the anger within a tenant. And by allowing them to come and get their property back, that would allow for the eviction that is to take place to happen smoothly, and also allow for the tenant to be able to get their personal property, which a landlord has no right to be able to get that property back and to be able to move on with their life. And so that is kind of the main arguments against the Tenant Possessions Recovery Act. I think that when we're talking with people in Annapolis and supporters, they acknowledge that there needs to be some type of mechanisms for tenants to get their property back. We've even had landlords state, in hearings that tenants should be able to get their property back. It's more along the lines of how are we going to make that happen. So I think those are the main arguments against, which obviously we don't agree with.
And that's currently all the questions we have right now. If anyone else has any questions, you can put them in the chat or feel free to raise your hand, and you can unmute and ask it personally if you would like. Looks like Erica has a question.
Yes, good morning. Thank you so much for this presentation. I do have a question around, is there any money for rehabilitation? Sound like the legislation is very good, but there are a lot of vacant houses in Baltimore City, and that rehabilitation would help house those folks. So is there any money for rehabilitation? Thank you.
Yeah, thank you. So I would look at the Affordable Housing Trust Fund, the Baltimore City Affordable Housing Trust Fund. If you just Google it, you should see a few things pop up. But there is money for rehab through that trust fund, and particularly for senior property rehab, so senior home ownership, where the seniors just need a little money to fix the roof or to replace the heater. That's been a very successful program that has been funded by the trust fund. And then there are a number of applications out there that folks can apply for to get money in order to do rehab, to create new rental housing in particular, that is funded by the trust fund, also targeting community land trusts.
Thank you.
Looks like Beth Harbor has a question.
Oh, hi. Thanks. This is terrific. Love all the work that you do. We're big supporters. And just back to the issue of, tenant belongings. I've been around long enough to know that when Public Justice Center and advocates were working in 2006 on the city law, the big argument from the landlords on why they didn't want tenants to access belongings post eviction was that missing diamond ring and the liability for something that was lost and that would have been stolen by the landlord. So it's kind of good that you haven't heard that, but that's something to watch out for, because the imperfect agreement that occurred at that time for the city and city council was to provide additional notice to the tenant of the date and time eviction, and allow tenants that information, which they'd never had before, so that there could be better planning for moving of belongings, when that happens. So be curious, both what you think about the meshing of the existing current city law, which has probably changed over time, and the impact of the court case around tenant belongings, and then the state legislation that you're trying to get put forward.
I'll jump in real quick. I mean, so I view the Tenant Possession Recovery Act as building on, you know, the good aspects of the Baltimore City law. I mean, it's virtually the same proposal in terms of the notice, right? 14 days advance notice of the scheduled eviction date. We want to expand that to cover tenant holding over cases, breach of lease cases. Tenants in those situations should know as well when the eviction's coming. And yeah, I don't know, Albert, it wasn't as big of a talking point for the landlords, right? This idea that they would be they'd be liable for the diamond ring.
Yeah, I mean,
like, you know,
it
go
was
ahead.
mentioned a little. It was mentioned a little bit in some of the testimony, but I would assume that, you know, the closer this bill gets to being passed, we'll probably hear more of it. In most states, there is a real expectation to keep the tenant's property safe. In most jurisdictions, that's just the nature of being a landlord. And that's what we found in most of these laws. I mean, there are 36 states that have recovery for tenants, and all of them pretty much say that the landlord needs to, within reason, keep that property safe, make that property available. Now, there are ways for the landlord, to either take that property and give it to a third party, and the third party holds it, or they can put it in another place. But that reasonable safekeeping is, we believe that's embedded within the business of being a landlord. And that's, you know, most jurisdictions in this country do that. It hasn't crippled the rental market in any of those states. We don't expect that to do that here. So we haven't heard that yet, but we have been thinking about that in pretty you know, far out avenues.
And I just want to add one more thing on this subject, which is that, like, some of the feedback we got was, look, guys, there's just too much, there are too many bills on that are helping renters this session. And frankly, you know, we're just too much. There's too much legislation. Put this one on hold for a little bit. We'll come back to it next year. So hopefully we can do that.
That's great. And yeah, so it might be coming, even if you haven't heard it so much so far. And then there was the court case, though. And so, you know, how does that mesh with the legislation, help you all?
I'm looking at you, Albert. This is oh God, I'm blanking on the name. What's the name of the case on appeal? Fourth Circuit just heard the case.
Yes, sorry. Yeah, so what is the name of that case? So we are of the opinion that that case doesn't really have any bearing on this legislation. I know that's been something that the landlords have brought up. I think, you know, they're saying, let's wait for the Fourth Circuit to decide on this case before we pass this law. But that law, that case revolves around whether or not the city violated the Constitution by not giving notice to a tenant that they would lose their property in the event of an eviction, which is a state actor. That's not something that we're dealing with. In fact, that opinion in the lower court absolved the landlord of that eviction, and so the landlord themselves privately, they're not a part of this case in that way. And so our argument is that this legislation, or this bill, the Tenant Recovery Act, would have no bearing on whether or not on either way the Fourth Circuit finds on that, because the Fourth Circuit is analyzing states' actions, the city's actions in regards to notice, and not the landlord's. And the name of the opinion is still not coming to my mind.
Codman, right? Is it
Codman. Oof. Okay, thank you.
We have two more questions currently. The first one is from the chat from Latoya McKay. Is PJC involved in any work around third-party screening violating the FHA?
Albert, I know you were working on the criminal record screening bill. I know it's not quite the same, but
Yeah, I mean, yeah, I think that's a little different. Maybe, I don't know, Latoya, if you can maybe give a little bit more insight on this. So the criminal record fair chance and housing bill, which came which died in the House, but that would have prevented a landlord to look back at a tenant's criminal record 5 years after their application. I think this might be a different question, Latoya, or is this a different area?
No, it's kind of encompassing of background checks as well as like their financial records and all of that. What happens is that a lot of the landlords and property managers, they're using these third-party screening companies. So although you're applying with one company, they're using another company to decide whether or not you're eligible. So it then goes into your source of income, it goes into your background, it goes into your job history, like all of these different things that aren't initially impacted, like your credit scores and all of that, like all of it. It's pretty encompassing of all things to determine whether or not you're eligible for housing.
Yeah, you're right. Yeah, so we've definitely incorporated that type of analysis on our source of income prep and litigation, mainly because a lot of what we are expecting a lot of landlords to say is that, well, this analysis 2.5 or 3, that's coming from this third party. We're not liable. We don't tell them how to do this check. They're the ones like a rent bureau or some other organization. They're the ones that are going through this calculation, even though we're sure that the landlord is giving them this calculation. And so that's how we've generally been thinking about these third-party screenings in that source of income prism, mainly because what's happening is applications are sent, the landlord sends this application to this third party. We still aren't sure exactly how they're coming up with these calculations, but they're coming back by denying them and saying they don't have the income because of XYZ or because of credit or something along the lines of that. That's generally how we're focusing on the third party screenings. And I think the Fair Chance of Housing Act, that was more on the specific landlord and criminal records more than credit reports and income verifications and the likes.
Our next question is from LaShonda Godwin.
Good morning. Thank you so much for all of this information. I'm so appreciative to be in community with everyone today. My question is, it comes from a family that we've partnered with. Well, first of all, let me just say 98% of the families that we partner with at Family Connections Baltimore are 98% of them are female-led households and Black women. And so one of the main things that we do at Family Connections is partner with families to ensure that their concrete needs are met. So housing is a huge part of that. And we know that when we're working with families, if caregivers are stressed, children are stressed, so we're trying to work with their entire family to support them with meeting their basic needs. Housing is a big part of that, food, and clothing and other things, concrete needs. And so one of the issues that we always come up against, especially with our limited funding, is when a family is facing eviction and we're able to support them with paying that rental balance, oftentimes they can still get evicted. And I'm wondering, is there any advocacy or is there a policy or is there anything around like being able to stop that from happening, because oftentimes, I mean, we have what we call our family needs and strengths assessment, where we ask this question about, like, how do families feel about where they live? If they wanted to move, could they move? And a lot of families are saying, yes, we want to move. Like, we have bed bugs and the landlord has not repair, we have all these repairs. We're trying to put our rent into escrow. And so, and then there's these credit issues. So we're like in between a rock and a hard place when we're trying to figure out, should we pay this landlord $3,000 that will then turn around and evict the family a month later? So that's one question. Is there any advocacy or policy around that? And then my second question is, Matt, you talked about some of the rehabilitation resources for families, and I was just wondering if you could drop those in the chat, or are there any links, or if you could repeat that, because we kind of missed that and we really do need that information. Thank you.
Got it. Yeah, so on the thanks for the question. So on the first question, I think that one of the things we have to do a better job of as a community is really coordinating the social services and the legal services sides of the equation, right? Because I think there's a real opportunity to leverage social services, and at the same time, if someone has an attorney, they can figure out what their rights are, how they can hold the landlord accountable for bed bugs, how they can access the new law that's going to say, tenants should get a refund of the rent that they paid when they've had those bed bugs, and the landlord should provide for relocation costs and security deposits. But maybe the tenant's also going to need some money to pay some of that back rent. And so how can we do a better job of connecting these two sorts of services and leveraging each other's strengths? And I'd love to have that conversation and talk about that more offline. Because I do think it's really important. Frankly, we're always looking for organizations that have more of a social worker model too, for clients who have multiple needs that we just can't address from a legal services perspective. So yeah, I'd love to have a deeper conversation on that. And then, and I apologize. Oh, for rehabbing vacants, the main thing that I think individuals can access is the cities that I'm aware of is the city's hubs program for seniors. Are you familiar with that? Through Civic Works, and then I think it's called hubs. I'll do some Googling while we wrap up, and I'll drop something in the chat here. But it's mostly for seniors, I think.
Thanks so much. I just dropped my email. I sent you my email.
Great, thank you.
Thank you.
I think I'm being told that's probably the last question. So I wanted to thank you all so much for coming today. I'm sorry that we had such a long PowerPoint in the beginning, but I really appreciate the discussion and for all of your support and partnership in this advocacy. And I'll kick it back to Janice.
Yeah.
Oh, sorry. Wait, real quick. I apologize. Sorry. I just want to recognize Samantha, who joined the call late, whose slides I took when she had to go to a coalition meeting. So I want to say thank you, Samantha, for all your work, and yeah, an important part of our team here.
Hi, everyone. Sorry I couldn't be here, but good to see you all. Thanks.
Yeah, again, thank you everyone for joining us this morning. Thank you to our amazing housing team for all their incredible work in this space, and their tenacity and their smarts and their resilience in advancing this work for year after year. Just sticking with it and doing what needs to be done. That's incredible. And certainly as part of PJC's entire staff, the development staff on the call as well, always fantastic at coordinating these conversations and getting the word out, and all the things. And then other staff members, I believe, are also on the call that support each other and support our entire economic justice and race equity work here at the Public Justice Center. And then, of course, all of you who care so much and know so much about this issue, our board members, our donors, supporters, funders, community partners, and stakeholders who really have invested in this issue and this cause for the long haul. We appreciate your support in this space, that you can go out into the community and talk about our work and talk about how important this is incredible to our ability to advance the work and the mission. So thank you, and spread the word, get connected. We love that you're here with us in this important work. So again, just thank you, everyone. And of course, it's going to be a beautiful day. And so hopefully everyone can get out and enjoy their day. And we appreciate you spending your morning with us. Thank you so much.